Hey there, everyone. Thank you for joining us today. Welcome to IP 101, what every startup needs to know about IP protection. I'll be your session moderator today. My name is Matthew Frederick. I'm a partner in the law firm of Reed Smith out of our Philadelphia office. We're also proud to have another office in the Commonwealth in Pittsburgh, along with 28 other offices around the world. I've been an intellectual property attorney for 15 years now, and I've been a part of this conference in some way, shape, or form since its inception. I'm a proud Penn State alum, so I'm happy to be able to join you today and participate in this conference. It's always a great pleasure. I'd also like to thank our incredible sponsors. Without them, we wouldn't be able to put on this conference in this event. That includes my firm, Reed Smith, who is honored to be one of those supporters. Joining me today is an esteemed panel, so I'm going to go ahead and ask the panel to introduce themselves, starting with Gary Keller. Gary. Gary, if you're there, you're on mute.
I apologize.
No problem.
I'm the CEO of Zoomhw, which is a biotechnology accelerator, and have spent about 35 years in life sciences with a focus on commercialization of intellectual property-based inventions, and a Penn State alumni.
Great. Karen, can you please introduce yourself?
Good afternoon, everyone. My name is Karen Keller. I'm first and foremost an Everly College of Science alum from Penn State, but I'm also the co-founder and a partner at Shaw Keller LLP in Wilmington, Delaware, where I practice in all areas of IP, including counseling, licensing, litigation, you name it, we do a little bit of it. So happy to be here and excited to tell you what we can tell you about IP and protecting your assets.
Great. David?
Hi, everyone. I'm David Perry. I am one of the co-chairs of the intellectual property and technology practice at the law firm Blank Rome. I am in our Philadelphia office where I've worked graduation. Well, I went to Penn State. I was a paralegal for a couple of years and have been at Blank Rome for about 23 years. And so my focus is on all things copyrights, trademarks, licensing, and certainly a very proud Nittany Lion, as was my brother and my sister. And I've been involved with this since I think the second inaugural conference.
Great. Thank you, David. So with that, we'd like to begin the presentation. And, before we really talk about the things that we've learned when we've counseled startups over the years, we'd like to sort of level set and, start with a very, very brief overview of intellectual property. It's important that we're all using the same vocabulary and at least operating with sort of a basic understanding of the different types of intellectual property and the things that they can do and protect and the things that they don't do and protect. So with that, we're going to do a very quick run through of the 4 different types of IP and then dive into our discussion on how it affects startups. So with that, Karen, take it away with patents.
Okay, and this is really going to be kind of the quick down and dirty for each of these. So I'll start with patents. You all probably have heard of this. Everybody's probably been telling you, make sure you get your idea patented before you, go to market with anything. And that is usually the case. Patents are government granted. It's the quid pro quo that the government gives you for a new idea, is that you get exclusivity for 20 years from the time of filing, meaning you can stop others from making, using, or selling your invention. It is country specific. So if you file for a patent in the United States, it will only protect you in the United States from others making, using, or selling. If you want worldwide protection or protection in other countries, you have to seek protection in those individual areas. To note, it's important when you get a patent and you're, issued your gold seal document from the patent office, that doesn't mean that there may not be other patents that cover portions or some of your idea. So it's not necessarily freedom to operate, which is another issue that you're going to want to ask either your tech transfer office or your IP lawyers, whether you have freedom to operate in that space after they look around and see what other patents exist. The 20-year term, just real quickly, is new in terms of, not new, but fairly new in the US in terms of the fact that it's set from the date of filing. It used to be, and for those that have been, familiar with patents for a while, that the United States was the first to invent country compared to some of the other countries in the world. And if you could prove that you invented it prior to somebody else, you would be granted that date. We're now kind of in conformance with all the other countries, and we use a first to file date. So you want to make sure that you get to the patent office with your invention as soon as you can. Okay, Matt, you can go to the next slide. And along the lines of getting to the patent office as fast as you can, there are two types of applications you can file when you first go to the patent office. The first is a provisional application. That's pretty much what I call the rough draft of your patent application. It's not very expensive. There's no specific formatting required. It pens you get 1 year once you file your provisional application. And then it does not start your 20-year term, but it does get you one date for your filing date. So in terms of you have some protection there. Once you meet that 1 year provisional pending date, you have the option to abandon what you did or file your non-provisional, which is obviously the more formal application, requires what you see in the application are your specification that describes your invention, your claims that set the metes and bounds of your invention. I like to describe it as the fence around your property. And then the figures that help describe the invention. That starts the 20-year clock, puts you in queue for a patent examiner to review your application, which typically takes quite a bit of time. And there are some exceptions to that. And then once you're granted that gold seal, you have the right to exclude others from making, using, selling, or offering to sell. One thing to remember, and we'll hear about it a little bit later, is that a patent can only be granted for something that is new, useful, and non-obvious. There are other options for protecting IP that are out there that my other colleagues will talk about. And one thing as well to remember is that your new and useful, non-obvious invention also has to be for a process, machine, manufacture, or composition of matter. And this has come up a lot. I bring this up because with startups, this comes up a lot with computer applications, which we'll talk about a little bit later. With that, I'll hand it off for the next portion of IP. Oh, this is just a slide that talks about the fact that startups hold quite a bit of the US patents, and more so when they are venture backed.
Great. Gary, tell us a little bit about trade secrets. You're on mute, Garrett.
As indicated, a trade secret relates to secrets and specifically secret information. The information has to have value. You have to maintain efforts to keep it secret, and it has to be something that's not available to people easily. You have to take efforts to protect it. So there are a number of things that you can do to ensure that your trade secret is in fact being protected. That includes contracts, non-disclosure agreements, having employee handbooks that address that it is a trade secret, and so they know that, and also how to address that, and non-compete clauses. Physical security, so putting things in places where people cannot get to them easily, or only certain people can get to them, and then strong IT security. Next slide, please. So what a trade secret provides is that you can pursue damages if there is a misappropriation. So either they've acquired it improperly or have disclosed it improperly, and then there is a caveat, which is that it's the owner's burden to litigate and the cost to do that, which can be very expensive. And so for startups, this can pose a real problem. There are many instances where there have been large damage verdicts for misappropriation. So you have to look at your particular situation and figure out if it would be worth it. And as far as taking a trade secret and providing it to someone else, often trade secrets are included in licenses as know-how. So, for example, if you have a method to do something, it will include what the method is and the know-how related to how to ensure through the process that the nuances, whatever they are also included to make sure that they can replicate that method. There are different laws that are available both at state level and at federal level to protect trade secrets, and that if there is an infringement that you would work through. Next slide, please. So there are lots of types of trade secrets and things that can be protected under trade secrets. This is just some of them, but the ones that are most common. So you can see R&D information, software algorithms, it's used a lot. Inventions often have components of it, designs, formulas, ingredients, devices, and methods. Formulations is one that I've worked with quite a bit because of the focus on life sciences. Many biologics utilize formulation at some level, whether it's cell culture or something else. And so often those are not patented. They're kept as trade secrets to ensure that their competitors can't just adjust one or two of the components that may not even be significant and have something else that would not be an infringement. Next slide, please. So we've all heard about trade secrets, different ones that are out there, whether it's Coca-Cola, which is one that's often referenced, but at a talk by Francis Gurry, the former head director of WIPO, which is the World Intellectual Property Office. It's a division of the UN, at the Jefferson Library. He pointed to the cases that they had in the hall, which contained Stradivarius violins. So Stradivarius violins are known as the finest violins in the world. And they're no longer available because it was a family trade secret. And when the last member of the family died, so did the process of how to make a Stradivarius, which I found very interesting. Next. One big difference between patents and trade secrets is, patents give you the ability to defend. And that is a very strong standpoint in ensuring that if you're doing commercial development, that you have the ability to do that and protect yourself if there is an infringement. With trade secrets, it is just misappropriation that allows you to pursue some damages, and all of the burden of the cost of doing that and the effort of doing that falls on the owner of the trade secret. So it's a little bit different. Next slide.
Great. Well, thank you very much, Gary. And David, please tell us a little bit about copyright law.
Copyright law is the area of intellectual property that protects original works of authorship that are fixed in a tangible meaning of expression, which is sort of fancy legal speak for works that people create that are recorded, that are written, that are memorialized in something, as opposed to just simply spoken or oral. Next slide, please. So this slide is just an illustration of all the different things around us that are ostensibly within the realm of copyright, from books to certain architecture, which is a little bit of a special area, certainly musical recordings, paintings, photographs, even choreography to a degree, sculptures, and certainly relevant to a lot of folks that are probably watching now, software, the code, the programming that's written. It's a complicated area in some ways because certainly a lot of code is perhaps in the public domain. Some of it may be open source, but not necessarily lacking in copyright protection. So this is what copyright protects: expression. Next slide, please. So in copyright speak, we often talk about a bundle of rights or a bundle of sticks. The copyright is born in the work once the work is fixed in that tangible medium that I described. I'll move on to registration in a moment, but even without registration, once the copyright is in play, once it's born, the bundle of rights that you have as a copyright owner include the exclusive right of reproduction, to create derivative works off of that original work, transmission for certain kinds of works for which that applies, distribution and performance and public display. This is what you'll hear about and what copyright attorneys and IP attorneys will talk about as the bundle of rights that comes with a copyright. Next slide, Matt. So ownership of a copyright. The default position under US law would be that copyright vests in the author upon creation. Now, there is a complicated, or at least a key nuance to that, which is noted here below, which is work for hire. One of the takeaways, I think, from this session, if anything, would be work for hire usually doesn't mean what people think it means. It does not mean that I hired somebody and they worked for me and I paid them and therefore I own the code that they created. Work for hire is defined in the US Copyright Act. It has a specific definition. If it's an employment scenario and you hired an employee and what they created was within their scope of their employment, it probably falls under the work for hire definition, the sort of employer-employee species. There's a second species in the Copyright Act, which deals with independent contractors. But be careful, if you hire an independent contractor, you need to have it in writing. You should put these magic sort of work for hire words in there. And it should be clear from the beginning that it's the intent that that work as authorship vests in the company from the beginning. Short of that, what you'll often find is that, as I said in the beginning, the copyright ownership is vesting with the author. And the way for it then to move from the author to a company or to a company down the road is by an assignment. So one of the key mistakes or one of the key challenges that a lot of startup companies and entrepreneurs have is that they don't cross their T's when it comes to ownership of copyrightable works, especially software code. And so that's something you want to have a good understanding about, or at least be consulting with someone who does, or with counsel. Next slide, Matt. This is a slide about what you might also hear quite a bit about, even in just sort of the ordinary press, which is fair use. It's certainly very common in the art world and music. Fair use is a concept under US law that essentially is a limitation on those exclusive rights that I described. But it's really, in lawyer speak, considered a defense or an affirmative defense. It's not easy to prove. It's often disputed. You know, if you call up your lawyer and you say, well, I think it's fair use, it may very well be fair use. The idea of proving it can be difficult. It usually turns on factors that are listed in the US Copyright Act, which include, you know, the nature of the work you're copying, the nature of the use you're making. What's the amount or substantiality of the work that you're taking? Are you taking the whole thing? Are you taking a portion of it? Are you taking a small portion, but it's the most important portion? And also, what's the impact on the marketplace for that work that you have copied? So fair use can be difficult. It can be a little bit easier in the education setting. There are certain education related uses that I think most people and most courts would agree are fair, but there are a lot of other uses in the marketplace, and there are a lot of companies out there making uses, even in the conduct of their business, that sometimes are disputed. And this slide here deals with copyright clearance. You don't clear copyrights in the same way that you would patents or trademarks. So if you come up with a work or you come up with a program, you can't easily expect your attorneys to be able to sort of go into a database and clear them. You want to be careful about where your inspirations come from as well. And the next slide, Matt, copyright registration. There is a regime for copyright registration in the United States, as I mentioned. The benefit of registration and doing it proactively is that it will avail yourself of the best potential damages in the Copyright Act. Statutory damages, sort of an election of an amount of damages, is something that you can have, but you need to have registered it essentially before the infringement occurs or within a very short window. So registering your copyrights, or at least consulting your attorneys on whether you should register a copyright. And in some cases you don't. In some cases you want to keep it as a trade secret like Gary described. It's very important. There's a note here at the bottom about copyright notice. It is always a good idea, and you do not need a registration, to be putting the copyright notice symbol, the year of publication. So, copyright, startup name, 2021. That's a good idea for any of your publications, especially the ones that get out there into the marketplace. So with that, that's a summary of copyright, and we'll turn it back over to Matt to talk about trademarks and branding.
Great, thanks, David. So really quickly, I'll cover a very high level overview of trademarks. So what are trademarks? So trademarks are things like symbols, like the Nike swoosh that you see on the screen. They can be words like the word Nike. They can be a slogan like the phrase "just do it," which is of course, again, a Nike trademark. They can also be things like trade dress, and trade dress are design elements of a product, like the shape of the Coca-Cola bottle, the color of a sweetener packet, or the shape and color of something like a pharmaceutical pill. And in rarer cases, they can include things like sounds, smells, and colors. So what does a trademark do compared to the other types of intellectual property? It performs a few important functions. Number one, it represents the source of goods or services. So, when you're on a road trip and you're driving down the highway and you see the big golden M, the golden arches, that's McDonald's, right? So instinctually, that's undoubtedly a famous trademark, and it allows the consumer to know the source of the services coming from behind that trademark are the McDonald's Corporation. Another important function of trademarks is that once consumers recognize your trademark, it allows you to distinguish yourself from your competitors. So it's always good to have a distinctive trademark that people are going to remember and sort of sets you apart from your competitors. And then finally, trademarks signify a level of quality to the public. The ability of companies to protect trademarks is not so much a benefit for the company as it is a consumer protection policy from the government. The government has an interest in protecting consumers, and they want the consumer to be able to rely on a trademark to signify a certain level of quality. That's why when you own a trademark, you're allowed to keep people away from that trademark, because you don't want multiple people using the same trademark at different levels of quality and confusing the consumer and having them buy a product or a service that's of a different quality than they expected. So those are some of the important functions of a trademark. And through our hypothetical, we'll talk a little bit more about the importance of trademarks. So the rest of our discussion today is going to center around a hypothetical. So we created a hypothetical group, a hypothetical startup. I'm going to read the hypothetical and then we're going to discuss it a little bit. So our hypothetical is called Zoomhw, which stands for Zoom Homework. The students who created it like to say, just Zoom it. So a group of 3 entrepreneurial students created an idea for a Zoom software application called Zoomhw that allows for the collaboration in preparing homework answers. The application scrapes documents and writings from a variety of outside sources, including commercial and academic institutions, and including former test files sample assignments, old test answers, and other scholarly and scientific writings available on the internet or uploaded by the user. The Zoomhw application displays the source materials that it's pulling from and allows for downloading and sharing of the source materials. The key feature of this product, or the secret sauce, is an algorithm that ensures that the answers are tailored to the question based on a profiling software architecture that takes a variety of things into account. There's a very positive response on the possibility that this software could reduce homework prep time and improve grades. The students who created it are unsure if the technology is patentable. However, in order to gauge interest, they've conducted multiple demonstrations of Zoomhw to other students, and they even got flown down to Las Vegas to present at a software development conference at which they described the intricate details of their secret sauce algorithm to a very impressed audience. A fourth student and co-founder recently dropped out of the project to focus more time on school. There's expressed inventor interest, and the group is contemplating the formation of a company. So Karen, let me start with you. As an inventor, you want to get your idea out there. You want to test it out and make sure it works. You want to have it peer reviewed. Do you see any issues here with these inventors talking about their invention?
So unfortunately, yes. There's two groups that they've been working with: students, right, and the conference in Las Vegas. Clearly, the conference in Las Vegas is the bigger issue. They were out talking. There's what's called at the patent office public use, public disclosure. Were you out there telling people about your idea? And I always talk to professors about this and science students up at Penn State when I say you may live and die by the publish or perish requirement of a university if you're out there publishing articles about what you invented before you go to the patent office to file your application. And it's very similar in the sense that if you're out there promoting it, giving away the secret sauce, if you will, to other people, the patent office may say that it was a public disclosure sufficient enough to bar you from getting a patent on your invention. The student demonstration, I guess I would say it depends, and Matt jump in, and Gary, depending on what you think. I do think if they were to have the students sign potentially a non-disclosure agreement, if they were to make sure that the disclosure they were using to gauge interest was under some protection of confidentiality, that those people could not further spread the word, that it was a limited group of people, they might be okay. But they definitely have to be careful with how public the disclosure becomes, and they want to take protections to make sure that it's kept confidential. And that's common, that people will go to, like, for example, here to a venture capital company or something like that to talk about investment. As long as there's some NDAs involved, you might be okay.
Yeah, no, it's this demonstration to students is a little bit of a gray area, but in general, it's always better to have a patent application on file before you start disclosing, or at minimum, have an NDA in place. You know, this is difficult for startups because patent attorneys are expensive, but it's typically a good investment if you think you have a patentable product, to be consulting with a patent attorney early on.
And if you're going to, and like we said earlier, if you're worried about the money initially, you know, go ahead and file the provisional on your own, even just to get something on file and create that protection, so that later, when you realize that there's some interest after you've gauged the interest of students and at the conference, for example, you can then go ahead and invest the money.
Absolutely. So Karen, let me ask you one more question. Who owns this invention?
It depends, a typical lawyer answer. So as of right now, everyone that provided some inventive contribution to the invention owns part of the invention, whether they're still working on the project or not. Now, you can alter that later on by asking that co-inventor who dropped out to assign his rights in the invention to the rest of the team. He's probably going to want something for that, a quid pro quo for giving up his rights to any future monetary compensation from the invention. But as of right now, all four inventors, the fourth student, and all of the three entrepreneurial students that are mentioned earlier, are owners and inventors on the application, if it's patentable.
And in the interest of time, maybe just a yes or no question. If they end up forming a company, typically best practice to assign the invention to the company or keep it in the ownership of all four individuals?
Ooh, yes or no? I would say typically to assign it to the entity. It avoids problems later, but that's just the short answer.
Very short answer. Understood. Well, thank you, Karen. So, Gary, let me switch it over to you. We talked about patent protection being expensive, and you talked about potential trade secret protection. But in order to have a trade secret, you have to keep it secret. So, if these inventors didn't want to pursue a patent, what parts of their invention could they keep secret with trade secret protection here?
Well, I think that the most obvious is the algorithm. And most algorithms are not patented. They're kept as trade secrets because they're easily modified and with the ability to have the same result. So they have shared the secret sauce during their presentation in Vegas. However, it is unlikely that they shared all of the details of their algorithm. They did not provide the algorithm itself, and so that would still be covered. The other thing is, it will continue to change, likely as the company improves the algorithm to improve the outcomes of the application. And so the coverage under trade secret would also continue to evolve and grow, providing better protection to the company.
So, practically speaking, how would they protect that trade secret? Any, I mean, it's assuming we're talking about the algorithm, the software code. What sort of things should they be doing or shouldn't be doing?
Well, with the three students that would say found a company, the details regarding the trade secret of the company and that they all have obligation as an employee to maintain them would be in their employment agreements. For contractors or others that would have to come and act in contact with that algorithm or the system itself, they would sign a non-disclosure agreement in order to do that, which provides protection from the escape of the secret through them to someone else. And so those are the two main ones. As well, there would be security on the computers that does not provide easy access. You have to have the passwords. And as well, if there is a master copy, it would be kept in a controlled location where others cannot access it. They may have only one part of the algorithm being worked on at a time rather than the entire thing. And then there's also the secret into how does it fit into the overall business model itself, because it's part of a system that at the end of the day determines what information is going to be provided to that student based on who the student is, what the student's interested in, what the question is, who the teacher is, and that relies on not just the algorithm, but the data that it's going to address.
Great. So, in summary, keep it secret, and similar to patents, if you need to disclose it, make sure you do it under an NDA or some other obligation of secrecy. Let me ask you a different question, Gary. So let's say that another group of students or companies sees Zoomhw, they love it. They don't have access to the algorithm, but they develop their own software program that does pretty much exactly the same thing. Is there anything our group can do there about that with trade secret law, or no?
I would say no, because they haven't accessed information from the company. They have independently invented a system that has the same application and achieves the same outcomes. And trade secret does not provide protection from reverse engineering.
Absolutely.
And we don't even know that they reverse engineered it.
Right. Right. Yeah. So that's a key distinction, is that if there's anything reverse engineerable about your product or service, it cannot be protected with trade secrets. So something to consider when you're sort of weighing between patent and trade secret protection is, can you truly keep it secret, and can it be reverse engineered? Great. Thank you. Thank you, Gary. So David, question for you here, and I think this is an easy one, but if something's on the internet, you can just copy and paste it, right? That's no problem.
That no, the answer is no.
Okay, why not?
That could be a yes or no question, and also I'll just anticipate the logical. Can you mute yourself? The giving credit also doesn't get you out of the issue. You're probably best to try to link to that kind of material, or seek permission. But yeah, if it's on the internet, that does not mean it's fair game. If it's on Google Images, that doesn't make it fair.
And do only startups make that mistake?
No, no. Blank Rome made that mistake. Actually, I found out recently. My law firm had a group that did a presentation. It found its way onto our website, and it used a photograph. Now, there was ironically a fair use defense and argument there, but there is a huge uptick of copyright enforcement going on the internet for photographs, for music and images. So be very careful.
So what if this product, Zoomhw, just displays content that's copy or pasted from the internet, but doesn't actually let you download it? Doesn't provide anyone else the copy. Is that okay, or not?
It still implicates one of the bundle of rights that I indicated earlier. It's the right of display. And so you could still be triggering one of the copyright owner's enforceable rights. So it might mitigate your damages or your situation. It might make it less offensive to the copyright owner, but that doesn't mean it's technically proper.
Interesting. So your slide showed examples of copyrightable works, beautiful sculptures, choreography, pieces of music. What about a former test question? I mean, is there really any protectable copyright in that?
You know, it can be a difficult question. I would lean towards saying yes. You know, whether one question alone is a substantial enough work, or whether it's a short phrase that would not fall under copyright, could be debatable. Certainly a larger set of test questions and the originality in their wording or their arrangement could be. So there's no obvious answer to that. And therefore I would typically tell a client, you should lean towards assuming that it is protectable.
What if you don't just copy and paste it? What if you rearrange it? I mean, copyright just prevents copying, right? If you just sort of reassemble the information in a different order, I don't know. What do you think about that?
You know, it's copyright decidedly does not protect an idea. That is for sure. Clearly, there are millions of questions that need to be asked in any ordinary test for any particular topic. There's probably, again, sort of a mitigation of risk in doing that, but it's a little bit of, you know, we'll know it when we see it. So originality should always be your goal. Rearranging and recasting, you know, it could essentially find your way into a derivative work, which again was one of the bundle of rights.
Got it. Interesting. Lots of stuff to think about there. So on the trademark side, you know, I'm going to handle some of the trademark questions here. And this is a very common issue that we see in working not only with startups, but pretty much all companies, is before you use a trademark, you have to make sure that nobody else owns any rights, not only in that trademark, but anything confusingly similar. So the trademark infringement standard is the likelihood of confusion standard. So here, the students have named their product Zoomhw. So Zoom, you can probably assume is a trademark owned by the company who's providing this fine software for us to be here together today on. And you can assume that they own that trademark. But what about Zoomhw? You're adding the word HW to it. Totally different, right? Probably not. So under the likelihood of confusion standard, if a consumer is going to think that Zoomhw is coming from the same folks who provide the Zoom software, that's a potential likelihood of confusion. That's a potential trademark infringement. So it's always critical when you adopt a new trademark or a name to make sure that nobody else can potentially object to your use of that trademark. It's called trademark clearance. And the risk here is that you adopt a name, you get a swarm of loyal followers to your product or service, and then a year later you get a cease and desist letter and find out you have to change the name of your product or service. Something like that can be really destructive to a startup, having to change their name, the name that people associate with your product, and that's called goodwill. It basically erases your goodwill. So something to be careful about. Just Zoom it. That's obviously a derivative of Nike's trademark. Just do it. Full disclosure: I do not represent Nike, but they have been known to be somewhat aggressive with their defense of their very valuable trademarks. So I'd be careful, taking a known trademark and trying to change it ever so slightly to pass muster. And then lastly is trademark marking. If you're claiming trademark rights in a word or a phrase or a logo, if it's an unregistered trademark, you can actually get rights in it without registering it. And the appropriate symbol to use there is the TM or the SM symbol. TM for goods, SM for services. Once you register your trademark, then that's our Circle R logo. That means the trademark has been registered with the U.S. Patent and Trademark Office. And registration of trademarks gives you certain benefits and advantages over non-registered trademarks. And the copyright logo over here is a red herring. You don't use the copyright logo on trademarks. Copyrights are for original works of authorship, as David had discussed earlier. So we're coming up on the end of our presentation here. So here are some key takeaways. I believe these slides will be available, and if not, feel free to reach out to any of us, and we're happy to share these. But these are some of the takeaways from this example that we've just given. I'm not going to go through them all, but feel free to peruse these and sort of take these to heart. And certainly today's presentation may have given you lots of questions about your own startup or your own ideas. There is a great resource at Penn State. It's the Penn State Law Intellectual Property Clinic. There's a very long link here. I apologize for the length, but again, if you can't find a copy of the slides or a copy of the link, feel free to reach out to any of us. You can simply Google our name and our firm, and you will get our contact information. The clinic is run by Andrew Sherman, who's the director, and his email address is right here as well. There's also actually a lot of great information at the USPTO website, which covers patents and trademarks, and the copyright website, which covers copyrights. So there's a lot of good information on there about things like provisional patent applications, filing a trademark application, things of that nature. So you can really self-educate yourself and help to shortcut some of the time that you need to spend with an attorney on these things. We have actually 0 minutes left. I do see some questions here. I apologize that we have not been able to get to them yet. So please do reach out to the Penn State Clinic, or feel free to reach out to any of us, and be happy to chat a little more about these. So once again, we'd like to thank our sponsors for their support. We'd like to thank you all for attending. And the next event, of course, is our keynote fireside chat with our keynote speaker, Kenneth Frazier, chairman of the board and CEO of Merck, which is moderated by Eric Barron, president of Penn State. So we hope that you'll join us for that. It should be fantastic. So until then, enjoy the rest of your day. Thanks, everybody.
Thank you, everyone.